Grahak Sathi, 22nd March 2025, Volume 5, Number 37. The importance of making nominations for assets. Important things to know about nomination. Making arrangements for smooth transfer of asset to family members in case of one's demise is an important part of planning for the future. Making a will and making nominations for various account and asset are two main components of this planning. Here we bring you important information about why and how to make nominations. What is nomination? When a person makes a nomination for any asset, he or she authorizes someone to receive the asset on his or her behalf after their death. Nomination comes into operation after the death of the owner. The specified asset is then transferred in the name of the nominee. Nominations also help in the transfer of the asset to the legal heirs. Why should you make nomination? Making a nomination will ensure that your asset do not remain unclaimed or become subject to litigation after death. Therefore, it will ensure that assets do not stay with the banks, insurance companies, etc., but can go to someone you trust and who can also help in the process of passing it on to the legal heirs. If a person dies and has not nominated anyone, the legal heirs will have to go through the process of producing many documents like death certificate, succession certificate, proof of relation, etc. This is highly time consuming and tedious. Also, the process needs to be repeated for each legal entity, banks, insurance company, etc. If nomination has been read and a nominee exists, such hassle are avoided. When the person is a nominee as well as the legal heir, and if there are no other legal heirs, the nominee will become the owner of the asset or property. Where the situation is different, one should make nomination wherever it is permitted. Also, a clear will should be made to avoid litigations after death. Role of a nominee. According to the general law, a nominee is not the owner of the asset, but a trustee who is legally bound to transfer the money or asset to the legal heirs of the owner on his or her demise. Therefore, a nominee is only a caretaker of the asset and will only hold the money or asset as a trustee. He is liable to the legal heirs and will have to distribute the asset to them. A nominee can easily get the asset transferred from various entities and also perform the role of a trustee of the legal heirs. Nomination versus succession. In case of succession, special laws exist based on religion and the bequests made under the will of the deceased. However, there are no general laws on nomination. Therefore, the rights of the nominee are determined as per the laws governing the subject of nomination, whereas succession rights are determined based on the personal law applicable to the deceased. Hence, nomination is only a temporary arrangement so that the asset of the deceased does not remain ownerless during the period until succession issues are resolved. Other considerations. The rule that the nominee becomes a trustee to hold the property on behalf of the legal heir and is liable to pay or transfer asset to the legal heirs can have exceptions. Provisions of each statute or law regarding nomination vary. Most statutes indicate clearly that the purpose of nomination is only to provide a valid discharge to the bank, insurance company or cooperative society, etc. And it does not exclude the legal heirs of the deceased from claiming the asset or property. There are some controversial judgments on the nominee's role. According to an important judgment, in the case of shares, a nomination made during the lifetime of a shareholder, upon his death, vests all the rights of the shares in the nominee. According to the court, the role of a nominee is different as per Companies Act and the Depositors Act, which govern the transfer of shares. The Act made it clear that the intent of nomination is to vest ownership rights of the shares to the nominee, provided that the nomination is validly made as per prescribed procedure. How to register nomination? The nomination is required to be registered with the authority which holds the asset: banks, insurance company, shares mutual funds trading and demat holding company, cooperative housing society, etc. through a simple unstamped form. The form is to be signed by the owners of the asset along with two independent witnesses. You have to mention the full name, address, age of the nominee and your relationship with the nominee. The acknowledgement for registration received from the authority must be preserved carefully. Nomination can also be made in joint accounts. The nomination can be modified, changed or cancelled anytime during the life of persons who made it. A separate nomination should be registered for each account, asset, fixed deposit, safe deposit, locker, etc. Where the nominee is a minor while making the nomination, the depositors or owner of the asset should appoint another individual who is not minor to receive the asset or deposit and amount, etc. on behalf of the minor nominee in the event of the death of the depositors. In the case of a deposit made in the name of a minor, the nomination shall be made by a person lawfully responsible to act on behalf of the minor. There can one or more nominees depending on the rules, law relating to the institution which holds the asset. Life insurance policy. You have to nominate one or more persons who would receive the benefit in case of your death during the policy term. This nominee can be the spouse, children, parents, a distant relative, or even a friend. Multiple nominees with their respective shares can be registered. Bank account. Only one nominee is permitted for each account. For different account, FD, savings, etc. held with the same bank, different nominees are permitted. However, nomination of up to 2 persons is allowed in case of jointly held account and locker account with common consent. Shares. Nomination needs to be registered at the depository participant level. Mutual fund investments. Up to 3 persons can be nominated. Nomination is done at the folio level by the fund house. All investment under the same folio will have the same nomination. Public Provident Fund. Multiple nominations also with specification of each nominee's share can be made. Editorial team. Chairman CERC and Torch, Praful Amin. Chairman CERS, Walter Vieira. Chief Operating Officer, Anindita Mehta. Associate Editors, Anusha Iyer, Rashmi Goyal. Editorial Assistant, Tithi Bhandari, Vandana Yadav. Address, Consumer Education and Research Center, 802 Grahak Suvidha Kendra, Sakar 2, next to Ellis Breach Police Station, Ashram Road, Ahmedabad 380006. Phone number 079 3533 7262. Email address complaints@cercindia.org. Helpline number 1800 233 0332. Dhwani Mudran, Shanta Mehta Digital Talking Book Library, Anjan Mandal, Vastrapur, Ahmedabad 380015. Voice over by Anal Dave.